There is one other point that landlords can and should consider, and that is sometimes they will have a lease which either there is a guarantor as well, or it was a lease that was assigned from one tenant to another, and the previous tenant entered into what is known as an authorised guarantee agreement with the landlord, where they guarantee the incoming tenants complying with the provisions of the lease, which would include payment of rent. In those cases, it is open to the landlord to have notices served on a guarantor and possibly a former tenant as well in certain circumstances, saying that the tenant hasn't paid the rent, giving them details and effectively putting the onus on them to pay that rent. If the tenant and the guarantor and possibly a former tenant do not pay, the landlord can also sue them. So that means that if they do issue proceedings for non-payment of rent, they could issue it against the tenant, a guarantor, and possibly as well a former tenant, or if they wanted to do so because they knew that the tenant wasn't good for the money but the guarantor or former tenant were, simply sue them. The only thing to bear in mind there is that there are certain deadlines relating to the amounts you can claim from former tenants on guarantors. You have to give them a notice within a particular period of time, and that's very important because once that time's gone, you've lost that opportunity. But I'm happy to have a chat with someone about that if they've got a query.